representative from our county council, which is Bre, to speak to us tonight to talk a little bit about what the development review process is that happens with major projects such as Central El Dorado Hills, such as the Vineyards project, other projects that people have been commenting on in social media and others, to really understand what's required by the state law flow down to the county, what we have to do to honor our oaths of office as elected officials, and ultimately the decision-making process that happens depending upon the type of project. So I'm going to ask Bre to give us a little bit of her background, and then we'll get into the discussion of the process. So thank you for taking the time to show up.
My pleasure, thank you. My name is Bre Moebius. I joined El Dorado County Council's office 3 years ago. I was actually married in Shingle Springs in 2007, and we moved to El Dorado Hills in 2011 when my son was 1. And now he's a 3rd grader at Oak Meadow, and I have a 1st grader there as well. So this is where my kids take some lessons. I think that's why I moved my job up here to this county, because I live here. Probably my favorite part is my son now is a little planner, and he likes to learn about all the projects and go drive them with me and remap things out. So it makes my job tangible. My job before that, I was 9 years in federal court, which is a lot less tangible for a kid, and a lot less local, obviously, of the issues, because they're more at a federal level. And I was also teaching law at UC Davis and McGeorge before coming to the county. So I'm really happy to be at the county. I worked a lot on land use in the last year with the Planning Commission, started representing the Planning Commission in March. Before that, I did the defense of the county, so when we were sued under the California Environmental Quality Act, I would defend the county in those cases. I also do a lot with Department of Transportation and the environmental review for public projects, so the bridges, freeways, those issues. I also did the cannabis laws, so if you recall, the very long ballot measures. You can be annoyed at me for how long they were. But I'm part of the implementation of the cannabis law now in the county. Also work on mitigation fees. I done airports, cemeteries, kind of anything. In a small county, you get to do a little bit of everything. So to give an idea of planning law, I can't really go over all of it obviously in a short time tonight, so I'm going to try to keep it at a very high level, but to give you a sense of what happens when a project comes to the county, how does the county handle that, and where is it that really the public, where you get to get involved and have your voice heard in that project. I'll give an overview, and then if there are questions, I'm happy to try and answer any. I'm not going to get project specific on anything tonight. I didn't bring anything with me on particular projects, although I did bring a little bit on Central. In the end, I can go over Central and kind of where it's at and where it's going from here. So planning is a lot of balancing, and there's a lot that constrains the county, and there's a lot of discretion that the county has as well. State law really is the starting point when we talk about any development project. The state has enacted numerous laws on planning, and they continue to do so every year. A great example is affordable housing. The state's determined there's a housing crisis. It's been going on a long time. So there's continual legislation to limit the county's ability to restrict affordable housing. So anytime there's a project that has that, we have to look at that state law and how that fits in and what that restrains of our ability as a local government. There's also the California Environmental Quality Act. Probably have heard of it as CEQA, and it's CEQA, but I've seen it called a lot of things. So if I say CEQA, that's what I'm referring to those, the California Environmental Quality Act. It's highly detailed, highly procedural, and it goes over the environmental review that has to happen before the county can ever grant a permit, approve a project, take some action that's discretionary, where the county has a say, and that project would have an impact on the environment. You might have heard the terms an EIR, which is Environmental Impact Report. That's the main environmental document under CEQA. You also probably have heard of a Mitigated Negative Declaration, or an MND. That is another form of review. It's just less thorough than an EIR. So it's a project that's not going to have as many impacts as a big project, and so you might do an MND on that. Planning and zoning law regulates how we can plan, how we can zone, what we can zone. So we're looking for that all the time as well. There's a Subdivision Map Act, which governs how we can divide land, how we can provide for subdivisions. The Mitigation Fee Act, which you might have heard of, that governs how we can levy impact fees. So when a development comes in, they have impacts not just on the county and not just the residents, but on the fire department, on the CSD where we are right now. And so the county has the ability to enact fees that any developer would pay per house to mitigate for those impacts. So we first look at state law, and then we also have to keep in mind a property owner's rights. Probably all have property here and wouldn't appreciate the county coming in and telling you too much of what you can do or can't do with your property. The Constitution restrains what the county can do for developer rights as well. So they have a right to submit an application, to put together a project and submit it to the county. The county has an obligation to process that application. So it's not our application, it's not our project, it comes to the county, we have to process it. The Constitution also limits how we can condition a project. So you may have heard of conditions of approval, which is when we give a permit out, we say, yes, you can do this, but here's everything you need to do to mitigate your impacts. But we can't put a condition on unless we can show a sufficient nexus between the condition imposed and the burden of that project. So we have to be able to articulate what's that project doing and how is it impacting, whether it's our roads, whether it's the surrounding community, before we can start putting conditions on. And just like we can't tell a developer, you can't do this, if they don't agree, we can't also say, then we're going to deny your project because you won't do that. So the courts have said it works both ways. We don't get to say, you have to do this, and if it goes too far and they say no, then we can't deny the project. We would also be challenged on that by the developer. The one exception to that limit, though, is development agreements. So essential, I think you've probably heard that there's a development agreement in the works. That's where the county can reach an agreement. So it's a contractual relationship between the developer and the county where they're agreeing to things that they will do for the county, but it's not subject to the constitutional limits that the conditions of approval will. So those are why you'll see those differently. The development agreement gives the developer certain benefits as well. It gives them the certainty of when they enter that development agreement that they get the conditions at that time as they continue to develop a bigger project. So you generally will see development agreements with bigger projects that are going to be developed over a longer period of time. Balanced with that, so we have all the state law we're trying to work with, our local ordinances as well, and the developers' rights, and then the public concern, and that's really where you come in. The supervisors are always cognizant of that, the planning commissioners are cognizant of that, and it's a public process, and so that's mainly what I'm focusing on tonight is what is that public process and how do you get to shape a project. CEQA and state law requires it to be a public process, and so does our county ordinance, and requires notice. The county generally goes beyond what state law requires as far as the noticing for a project. And then balance with that too is the county concerns and the county's vision and carried out with supervisors as the policymakers on what do we want El Dorado Hills to be, what do we want El Dorado County to be, and what types of projects can we be approving on that. The supervisors are tasked with making decisions that are considered the policy decisions or legislative land use decisions, and that they are the first and final authority on those. The county's vision really is memorialized in its general plan. So I brought it with me because it's considered the constitution for land use development. So this is my copy of it, but it is available online. State law requires us to have a general plan. It's supposed to be a long-term, big picture if you think of it, the goals and policies of the land use and development and everything really for the county. State law lays out the framework, but every county's general plan is different because every county is different. So you have mandatory elements, which you'll find in our general plan, which are land use. So that's going to be land use designations. Where do we want the development to be? What type of development? How dense do you want it to be? I know with vineyards, that's been a question as well about density bonuses, which is where you'll find that is in the general plan. Traffic and circulation. So probably if you're here, you're familiar with Measure Y, Measure E. Those were voter initiatives that amended the general plan and the traffic and circulation elements. And you have the traffic and circulation policies that limit the county's ability to give out a permit if there's impacts to level of service that aren't going to be mitigated with that project. Housing element is the one element that the state reviews and certifies, and that is because of the housing crisis. So we as a county, the state meets and they work on it, and they give us what's called our RHNA number. It's our Regional Housing Needs Allocation. And they say, El Dorado County, you're responsible to come up with this much housing. You have to have a plan to do it. You can't have constraints to it. And that's where our housing element comes in, and the state is more, I wouldn't say opinionated, but it's not the right word, but they have retained more power for themselves with the housing element than other elements. There's a conservation element, an open space element, agriculture and forestry, and noise and safety. So those are the mandatory that the state says you need to think about as a county and how you're going to develop. The El Dorado General Plan also covers public services and utilities, parks and recreation, and economic development. As a whole, it's a big document. There's a lot of policies in it. There's a lot of implementation measures in it. And the state says it has to be internally consistent. So within one policy, for example, housing, we have to be consistent with all those policies. And if you read it just on a slow day, you know, sit down and read the general plan, you'll see it's really broad and for it to be consistent, difficult to do. But it also has to be consistent as a whole. So all the policies together have to be consistent and try to work together. So it's a hard task, and the state limits our ability to amend it. If you think we are one of the few, I think we're the only nation now actually that has the original constitution that started our country and hasn't changed, right? Because you can't amend, it's hard to amend the constitution, so we don't just change it every year when we are working on it. And because the general plan is kind of looked at as our constitution as a community, the state limits our ability to just amend it. So we can't come in and do it every month and make amendments. We can bundle some amendments, which allow us to do more, but it's not something we're supposed to be coming to the supervisors with, constantly changing it. It's supposed to be a long-term plan for us. When you have a project, the supervisors have to find, the planning commission has to find that it is consistent, substantially compliant with the general plan. So you'll see when you look at a project, you'll see a staff report from planning, and it will go through the policies of the general plan and explain why it's consistent. And that's a finding that they have to make. And that can be challenged just like you can challenge under CEQA, you can make challenge under general plan inconsistency. But the courts have recognized that the document this big, no project is going to fit perfectly in there, because this is a broad, overreaching ideas and policies and goals, and a project is a concrete piece of, of development in front of you. So they said that it doesn't have to be in perfect conformity. Every project doesn't have to carry out every policy perfectly, but that has to be substantially compliant with the general plan. So that's why you'll see that in the staff reports in that discussion. When we talk general plan, then we have specific plans. So if you think general bid plan, specific plan is a much smaller piece of the county that state law provides for you to come up with a plan with. So the central project does have a specific plan proposed. One that you may also be familiar with is the Serrano specific plan. So that's called the El Dorado Hills specific plan. It was adopted in 1987. So if you think of how long ago that was, and that's the idea of the specific plan, is you come up with this idea for a larger development, and then it's developed in small pieces. So Serrano's still at the board right now with J7, the J7 project for Serrano, which is not the last, but one of the last projects of the Serrano development. So the Central would similarly propose a specific plan like that that will be developed in phases or pieces, not an entire development at one time. But the specific plan covers what's the different land use going to be. So it maps out what's included, what area is included, and what's going to be the land uses, where are they going to be, how is the traffic going to be impacted through there, how are the internal streets going to run. But it's a much broader level. You're not going to see a map right now that shows you the parcels or where each project is exactly going to be. It's going to be at a more broader level, like the general plan would be. Any questions on what I've covered thus far? I can go to the application. Yeah? The general plan? Yes, a lot. I mean, not as much as more than the Constitution. So if you look in and actually there's a new one I got called today, the new one's on its way, and I'm probably one of the few people that gets excited. But this one was amended last 2018 for the big book, but there just was amendments, I believe, 2 years ago, but this covers all the amendments if you're curious afterwards when they come. It's by resolution, so it goes to the Board of Supervisors. It will go to the Planning Commission first, and then to the Board of Supervisors.
So that's not approved yet.
For Central? No, and I'll get to that. So no, Central is nowhere near approval. the general plan has been amended many times for different projects, or I think the last amendment last month was the economic development policy had an amendment, I think, changing where TOT tax is going to be spent was the last one that was before the board. So there's minor amendments when something's not working or need to be changed. Yeah.
The general plan, I believe, can be amended 4 times a year. Is that correct?
Yeah.
Is that a calendar year or a government county fiscal year?
I would have to look at the planning law. I don't have that memorized, but I know the section, but that's on my desk. But you can bundle. So it's not just, and it depends on the element, but you can bundle it so it's not like one line doesn't count and voter initiatives don't count. But I'm happy to follow up with you on that, but it's pretty laid out.
But a project-specific one, like say for Central or Vineyards or whatever it might be otherwise in the county, it's 4 times a year for those?
Well, you'll tend to see them grouped together. So you might see an amendment for a project with the economic development. You'll see them grouped. It doesn't say you can amend more than one. Like we group them. Right, making sense? So you'll see them bundled, okay, so that you're not limited to 4 amendments. Does that make sense? So sometimes it takes planning. Planning and really comes from planning department. A lot of them, they have to kind of look ahead. What do we see coming, so that they can bring those amendments together, so that we're not running up against the 4 amendments.
But I think it's a fair statement. To my knowledge, the county's never gotten to the point that they're doing 4 and trying to cram them through. Because like Bre says, they're bundled. Typically, it's 2 or 3 a year. Sometimes it may be less than that. It just depends on what issues are brought forward. One that happened not too terribly long ago was the amendment that was made to change the density constraint for the town center apartments. Because basically we had a general plan limitation, I think it was 24 dwelling units per acre. This was a unique project, a unique opportunity from an economic development perspective. It was weighed by the board, and we said this is standalone by itself enough to allow this one-time change in the general plan to do that. It was not a carte blanche. Anybody that proposes the same kind of a development anywhere in the county is going to get that privilege, right? So you do these things judiciously if you're modifying the general plan. And then ultimately, on major general plan amendments, it's going to go back to the voters typically. It's not going to be just the board making those decisions with public input always, right? So I think the 2004 general plan that we're operating to today with amendments was actually a voter-approved type of document. So that's the heart of this, is get the voters involved when you do major updates, but recognize you need to have incremental updates in between those major updates.
And yeah, the general plan is not required to go to the voters as a whole, but in our county it did. It was enacted. I just was looking, so 2006 there was 1 amendment, 2007 there was 2, 2008 had 4, so, it kind of varies, but, and this is the beginning of the general plan, but it tells you what was amended and what resolution it was that amended it, and then you'll see a strike-through version of it, but there's few policies, Measure E is one, where the county can't amend it, and that was through the voter initiative when they enacted some policies. If you follow that case is still on appeal. We represent the county in that case, and we've been waiting to hear from the court for, I think, well over a year now. It's been fully briefed, so we're still waiting on that. No other questions? I'll move to the app. Yeah.
So, Bre, when you're referring to the Constitution, I'm assuming you're referring to the big guy?
The United States Constitution, yes.
Okay.
There goes my federal background sneaking out. It does that once in a while, but
elected officers swear allegiance to the United States Constitution and the Constitution of the state of California. So they both have a role for elected officials to abide by that legislation, those rules. So.
And a lot of those constraints on us, when I talk about that nexus requirement we condition, that comes from the federal Constitution. And it's actually U.S. Supreme Court cases, so we're not talking local cases, but Nolan and Dolan are the main cases, but that was decided by the U.S. Supreme Court. So even locally, we have a lot of federal constraints on us in land use, and then, law enforcement is probably the biggest one. You'll think of the federal Constitution with 4th Amendment, 8th Amendment, and there. So we could do civil rights. That's what I used to teach. Want to change topic? So the application for a project. So how does it start? And it's a long, slow process. And I'm sure if there's a developer here, they complained about how long it takes. But it's because there's a lot the county has to do. So the developer, though, submits the application for their project. The county, as I said earlier, has an obligation to process that application. The zoning code, so Title 130, which is here but also available on Muni Code online, talks about that procedure, the fees they have to pay. We review for completeness, we work with them on the information, and then we really start the process. Central, for example, was submitted in 2012 in November. If you think of how long it's taken to where we're here today. So when that process starts, it triggers a lot of work on the county side. A lot of times that's done by consultants, but beginning the environmental review for the project, hiring consultants to study traffic, to study fire, to study all the issues that would be around that project. So that's all happening really before there's a lot of public involvement, unless the developer chooses to have community engagement meetings, which I know that I've heard the board multiple times and the planning commissions multiple times encourage developers to do that, to get out in the community early on and to get feedback early on so that they can shape that project. In 2013, after Central, the board enacted policy J6 that does provide the general plan amendment projects that meet the certain criteria to come to the board and get conceptual approval, or requires them to do that, so that the county can also, early on when the project is still in development, make suggestions or talk about what they're looking for, what might be appropriate. Because when that application comes in, it doesn't come in as, here's our project. You're going to go through the environmental review. That's going to shape the project. You're going to see wetlands that you might have to mitigate for. You might have to move what is happening to avoid a wetland. There might be cultural resources that you don't know about yet because you haven't hired those consultants. So during that time, with Central just from 2012 to 2019, that's what's all happening and shaping and changing that project as you're going through that review period. So then we get, let's go kind of fast forward all those years, and we get to decision time and public involvement time. And to determine what that is, you first look at what type of review you're going to have, and that's also in the zoning ordinance on Title 130 that lays out. And the three types you would have is staff level review without notice. That's going to be a very ministerial, your building permit for your single family residence that you're checking the setbacks on the engineering plan. Staff level review with notice. So it's something that's not going to go to a hearing, but the zoning code or state law says you still need to have notices surrounding property owners, and so there'll be that notice. Public hearing, obviously, with notice. So the public hearing is not even just the big projects, there are smaller projects that, cell towers are public hearings as well, because they really have an impact on people closest to them. So the notice, as I said earlier, we definitely meet, but we generally exceed what state law requires, and that's a policy decision by the county. With Central, for example, notice letters went out within a mile of the parcels for that project. And I brought them out and I was curious, but it's a large swath, because Central is a large, and then Pedregal and West are fairly far apart, and so that mile goes very large on what the notice is. So once you know what type of hearing you're going to have, then you have to figure out who's the appropriate decision maker. The lowest level review would be the planning and building director, and that's going to be very minor approvals, administrative permits, minor revisions to a permit, or a temporary use permit, so maybe a grade event. And these decisions can either be appealed to the planning commission or to the board. The next would be you would have a zoning administrator, and these would have a public hearing often, but they are minor use permits, conditional use permits that aren't very complicated, revisions to one of those permits or a variance. But the zoning administrator has the authority to always refer something to the planning commission. So that just happened a week ago because of the public interest in what might otherwise seem as a division of land into 3 lots. And so that was referred to the planning commission. And your next level will be the planning commission. So Commissioner Vega is your District 1 commissioner on that. It is a 5-member board appointed for each one of the districts. And those are all public hearings. The planning commission will hear conditional use permits, design review permits, development plan permits, which is a PD you might hear. And a PD gives some flexibility to depart from the strict rules of the county. So one example is the county's sign ordinance that limits how large your sign can be, how many signs you can have. With a PD, it gives some flexibility for a developer to maybe have a little bit higher of a sign or a little bit larger of a sign without having to go after a variance, which is a little more difficult to grant sometimes. And of those decisions, the PC decision is the original decision maker. So they either approve or deny that application. Anybody, though, within 10 days can appeal that to the Board of Supervisors. So then the Board of Supervisors would hear the appeal of that decision. The land decisions I mentioned earlier were there legislative actions where the courts have considered them legislative or policy decision actions. That's going to be with development agreements, specific plans, rezones. That authority, the original authority to make that decision, rests with the Board of Supervisors. Under the state law and county code, any decision like that that is made by the Board of Supervisors, it provides to go first to the Planning Commission, where they review and make a recommendation to the board. And really one of the benefits of that is the Planning Commission is a very narrow focused body. They hear planning applications and development applications, and the calendar, I think, since I've been on, we had one that was 7, which was a long calendar, but generally, 2 to 4 items on it. So they have the time to really get into the nitty gritty on, what might be a small lot line or where something's going or where this one tree or how that impact is. And so it has the benefit, and we have planning commissioners who invest a lot of time in reviewing all the documents and emailing their counsel.
That's right. Way too much.
And so you have that expertise, and you also have that time commitment. Now, when you think of it, this was first heard for the first time by the Board of Supervisors. I'm sure you've all, if you're here, looked at a Board of Supervisors agenda. They can have 50 items ranging from a public safety issue to the library to ambulances to a contract for a road improvement. And so it's so diverse, and their ability to carve out multiple hours on that one hearing that day is more difficult. So it gives that benefit to really have something really examined in detail before it comes to the board for their final or for their decision in that one. And the same with an appeal. If they hear the appeal, they have the benefit of all the work that's been done at the Planning Commission level. So that's my plug. If you're here, I think you're interested in projects, that Planning Commission is the time to get involved, because that's really the time that we've already had 2 hearings on Central. We have 2 more set, but that's really the time where you can comment, and there's the luxury really of the time to make those adjustments now that sometimes it's harder when you're on the board and the calendar, has, I don't know how many items on it and several, scheduled. So that would be a plug there. But during all of this happening, right, and the public comments and the public views coming in, we also, and probably my role, probably I'm the one expressing it most of the time, is has to think about the rights of the applicant. So the applicant has due process rights that come from the federal constitution, that they have the right to a fair hearing and a fair decision maker. That is a right that if they ever felt like they weren't given that with certain types of approvals, they can challenge the county that they didn't get that fair hearing or they didn't have an unbiased decision maker. One of the cases says procedural due process in the administrative setting requires that the hearing be conducted before a reasonably impartial, non-involved decision maker. And with small counties, El Dorado County, relatively compared to other counties, is small. So courts have recognized that John, or both Johns, are going to be familiar with that. They know where Central is. They know the properties that are going to be affected. So they're not saying that you have to be completely naive or not understand the concerns of the community, but that you need to be unbiased and that you need to have an open mind and need to be listening to everything that comes in before making a decision. And so the courts have said if there's concrete facts that show that a decision maker has an unacceptable probability of actual bias, then they can be challenged for having made that decision, or they can be challenged up front saying that they don't get to be a part of that decision because they've expressed actual bias for or against a project in advance of it. An example would be, express statements attacking a project before it's even come to a hearing, and you have it as the decision maker have the chance to do that. The same thing, while due process requires a fair decision maker, it also requires everything that the county decision makers base a decision on to be available to you, to be in the public record. And so that's why the public hearings sometimes can go a long time, and you'll see so many attachments on Legistar, which is where you can pull the agenda item, because everything that they're looking at has to be available to you. Same thing if a commissioner or a supervisor went out and doing due diligence goes and visits the site, for example, or meets with the developer to talk about it, and if they obtain information that's not available on Legistar and that's going to be a basis of their decision, then they have to disclose that under the due process laws and say, this is what I'm also considering. I walked the site and I thought the topography, looked a little bit different than I see in this map, and that's playing into my decision. That then gives the public and also the applicant the opportunity to respond to that and to rebut that. So those are two issues with due process that go hand in hand. And for those reasons, so that we're ensuring that there's not a claim of actual bias and that all information is considered, our office advises against any decision maker taking a position on a project before the public hearing has closed. Yeah.
It used to be that when a neighbor was planning to do something, all the neighbors were notified of that. Is that happening anymore?
So that's what I was talking about earlier. That first step really is what level of review, and there's staff review with notice and staff review without notice, and certain approvals are considered without notice and certain aren't. So it's the zoning code that lays out what is required of notice and what's not. So if there's some approval, I don't have an example offhand, but if there's approval that doesn't require actual notice, then that's not happening. But for any development project or for conditional use permits where the law really considers it to have an impact on neighbors, then there is notice.
Well, I think a major development like Menard, my property actually has been notified of what they're going to do.
And so if you look at the Legistar item on one of the last attachments normally is it's called a notification map, and for Central, this is what it looks like, but so it shows
Yes.
that. So I would guess it sounds like you're very close to that project. That you would have, for that project, yes, you would have received notice on that.
Instead of avoid all this problem. Thank you.
So I would pull up the Legistar item and see if there's that map there. The courts do give a presumption if the county says that we followed our normal procedures, we drafted the notice, we put the notice in the mail through the normal procedures, that we are given the presumption that that notice was sent and that notice was received. Obviously, we don't have the ability to hand deliver notice to everyone, so we're relying on the Postal Service, we're relying on addresses being updated. There are other avenues too, though. You can subscribe on the county website. You can subscribe to the Planning Commission or to the board items, and then you can check the boxes you're interested in. So that there would be planning. So anytime a planning item comes before the board or for the planning, you can get an email. So that's another way, that you can always watch. Obviously, you can read agendas, but that's a big burden, I think, on anybody to constantly be reading agendas every week to see. But so there are other avenues. Not suggesting you do that. But you can subscribe. Though. If there's areas, planning is one that you really interested in land use. I would recommend subscribing to that because there's going to be ones that maybe aren't in your area directly, so you're not going to get the notice, but you might have interest in attending or staying on top of that. So that's another option as well. But I think that is all I have at this point. I can talk a little bit about Central unless there's any questions more broadly.
You talk about the agenda for next Monday.
Yep, I have that, yeah.
Because I think that'd be a good segue to let people know what's going to happen at the special Planning Commission hearing that'll be done in El Dorado Hills a week from today. So if you're not aware that I have it on the supervisor's comments, but Bre, I think, has some copies to share with you. So if there's questions on how that's going to proceed, what the steps are, we can answer those tonight so that there's not a false expectation of what that's all about. So we thought for clarity purposes, we wanted to make sure that that was available to people.
And I wanted to thank Steve Ferry, because I called Steve to help set that up. So thank you, Steve.
Yes.
Appreciate that.
So as I said, Central was submitted in November 2012. So here we are over 7 years later, and where are we at now with that project? Given the nature of its entitlements, it will be decided by the Board of Supervisors. So the board will be making the decision on it. But as I said, it is the Planning Commission for the review and recommendation. We have already had two hearings, one November 14th, one December 12th. If you missed those and you're interested, you can go on the planning or the county website and pull the agenda, and there's a recording of it. So all of that is available to you. But as Supervisor Heidel said, our next meeting is in El Dorado Hills, which is not typical of most projects, but the county recognizes this is a big project with a lot of public interest and a lot of public interest in El Dorado Hills. And so that meeting is set at 6 o'clock at District Church on the 13th on Monday. And then there will be a fourth hearing for deliberation. So public comment Will likely go to the chair, but will likely be closed on the 13th and then come back for a public hearing on deliberation. So it'll be open to the public, but not taking additional comment at that time. So what I did print for you, when I said Legistar, this is what Legistar is and what it looks like when you pull an item. Is everybody familiar with this, or I can kind of go over, or would anyone like me to go over it a little bit?
Maybe just a top level
yeah.
summary, you don't have to go through all of it.
So,
explain what it shows, yeah.
This is the main, how the project description is. I'm going to get into that later, but if you look here, here's all the attachments. So every public comment that comes in gets attached to Legistar, becomes part of the public record, and that's the public record upon which the decision makers base their decision. But you will also see the environmental impact report there. You'll see the supporting studies. You'll see the staff presentation. So everything is added to Legistar as it goes through. When public comments come in the day before, they're put up on Legistar as well. But if you flip the page over on the back of the first page, it talks about halfway down, what are they asking for at a very big picture level? What approvals, what entitlements are they seeking? So they're listed out there, but the general plan amendment, and that's partly moving to the zones of the specific plan. They're seeking to amend the El Dorado Hills specific plan, and that's what most of us would think of as Serrano. So they are seeking to take land that was zoned for development within Serrano, move it into Central, and then it would go into open space there. So there is a little bit of land switching between the plans. They are seeking the specific plan adoption, so that's the Central El Dorado Hill specific plan. Like I said, with the El Dorado Hill specific plan or Serrano, that was 1987, right? So it is a document that is supposed to be long-standing. They are seeking to rezone the property, a large lot tentative subdivision map, so that's not, like I said, you're not going to know the individual parcels. It's a large lot at this point, 6 parcels, that allows them to then finance and do that. A planned development permit, and then the development agreement itself. And so all of those documents are available on Legistar, and I believe they're going to traffic on Mondays. DOT is going into some traffic issues on Monday as well, and then public comment is, I think, the primary goal, so that people in El Dorado Hills have had an opportunity to comment and give input on the project. Any questions on kind of this document or at a broad level about the Central project?
I think my first suggestion would be that maybe you condense what you've said in over the last 25 minutes to about 5 minutes, and that you ask Commissioner Miller or Commissioner Vega, you ask Chairman Miller to have Bre do a presentation like this for about 5 minutes, explaining to, I think, the many more people that will probably show up next Monday at the district church for the hearing about what the process involves, because I think that might answer a lot of questions people might have and might take a little angst that might be present at the meeting.
Yeah, we have a commission meeting this Thursday, and so we could talk about that a little.
And as I said, I represent the planning commission, so if you come to any planning commission meeting, I'm there obviously advising the planning commission, so I will be there, happy to do that if you'd like me to do that.
Does the plan, when they try to implement these rezoning, do they use some of the state law incentives, like, okay, we're going to put a bunch of affordable housing into this so that you can't stop us? Is that going to be part of this type of strategy that they're going to have?
I can't speak for the developer. I can tell you right now the developer is not proposing affordable housing. The developer has not proposed affordable housing at this time. There is senior housing as an option, and with senior housing, the number of units can be increased. And then if there's not senior housing, then the cap is a little bit lower. But there's not a proposal for affordable housing at this point. There's multifamily, kind of more duplex style as well.
So there's 4 categories that typically accommodate affordable housing terminology. The one they qualify is called above moderate income. So it's the one that's easiest for everybody to fulfill. So it does fulfill part of the RENA requirements for housing, but it's not what most people would consider the affordable, and it's market rate housing and not something that would encourage young families to be able to get their starter home or those kinds of things. So it's a different category. You talk about above moderate. It's the more exclusive type of housing.
And the state law that really limits the county that I referred to earlier is not on the type of that housing. It's the lower income housing that triggers the protections of state law.
And we have been talking to them about moderately priced homes for Central. so far, I don't think they have any stomach for that, but we'll continue to discuss that.
I spent a lot of years in the housing industry making home loans to people, and the moderate income they're talking about is roughly between 55,000 and about 110,000. Those are not exact numbers, they're just kind of. So people who qualify for home loans, if they qualify on income at 3 or 4% interest, which offhand I didn't see much of in my career, but they can actually qualify for some pretty good sized loans. I mean, you're talking $500,000 that they can actually get into. So it's not like you have to build some $280,000 homes or $215,000 homes to get the moderate income people into the housing that you can provide.
But to get to the very low income, the bottom run,
That's
those
your
are generally
problem. That's your
rentals,
problem, John.
and those are multifamily, and the number for a family of 4 ends up being a rent that's $1,000 or less per month for very low income affordable housing, and every county is supposed to cover some of that. That's our true challenge, is how do you get to that level where you can provide a reasonable housing, even if it's multifamily, at $1,000 a month rent or less. It's almost unachievable given a lot of different things that are going on, but yet the state through SACOG and the allocations we get through RENA are requiring those numbers. So,
One party state.
no disagreement, Steve. We don't need to go there though. Okay, a couple more questions and then we need to kind of put a wrap on this. But
Does this list include everything that the county has received from the developer for this project?
I don't have, no, it wouldn't have, I'm trying to think of what an example.
Is there anything
So
you
a
know-
draft, well, because if
Is
you
there-
go, here's an example, if you've been
Is there
environmental.
is there anything that you know of with state law, county ordinance, would allow the county to withhold from the public any information that they receive from the developer on this project?
So the drafts is one example under state law. We are
Pardon?
not draft documents, so a document when it's in its draft form. So if you think of a 300-page environmental impact report, it is going to go through numerous rounds of drafts and editing and working through
So
it.
this would be, but the final.
The final
would
is
be
here, yes. I'm trying to think of, what you might not see here, I think, is sometimes we'll have, I don't think, yeah, they're not there, that when they have to hire a consultant, and we have an agreement with the consultant, that agreement isn't here, that just shows how it's paid. So there's things that when you get to, if you end up in litigation, that would be part of the administrative record, but that wouldn't be put here, documents like that. What state law requires to be here and to be considered is all going to be put up here, but you're going to have a lot of draft documents, emails. There's going to be things, so a developer might have sent us an email, that's not attached up here. So we might have asked the developer a question, what were you thinking of for this one piece? That's not there. So I don't want to say you have the entire universe because you don't.
well, let me provide one caveat. Our staff is not perfect. They do make mistakes. Everybody does. It's human, right? It's human nature.
I don't think you should make a mistake on this.
No. Let me give you an example. I know that our planning commission has found items that they believe should be part of the public record
Okay.
that for some reason, not proper judicious review or whatever, were not included in the public record that's been put out. And the planning commission is asked to please get those placed in the public record. And our planning department
this.
has been accommodating those things. So I'm not sure what you're referring to, Buzz, specifically, but it's a checks and balances.
Specifically.
Pardon?
I say I'm not referring to anything specifically. What I want to know is just a complete listing of everything the developer, excluding drafts, everything that the developer has submitted on this project.
So, and then another good example is cultural resource studies. They are not here. They are not here because state law includes us
What
from
is
putting
that?
this. Cultural resource studies.
Those
So,
are confidential in nature because of the sensitivity of cultural resources and people wanting to go treasure hunt, right? I mean, there's
so
reasons.
I think, my answer is no, not everything in our files or given, but if it's not there, there's a reason. There should be a reason, like Supervisor Heidel said,
But in
mistakes
this
are made.
case, there is something legally that prohibits that from being disclosed, which is understandable.
You have to lawyer the question, so I'm be very specific on that. But no, anything that should be there should be uploaded there. And this is planning, so I know I'm here kind of giving this presentation, but this is all run through the planning office. Our office is obviously involved, and reviewing that, but we aren't maintaining that or putting the documents up or reviewing every document that comes through either.
Question, Bre. This central project includes two uniquely different components. One is a piece of property that has been zoned residential for a long time. The other has been zoned open space recreation. The fact that there are two dissimilar origins, I'll use that word, does that impact in any way the ability to be looking at both of them at the same time in this?
So I think if I can kind of break it down a little bit, the reason that the projects are combined is because that's how the developer brought the project to us. So it's not the county decision, wasn't a county decision to combine those under one specific plan. I think that's also why you're seeing so many hearings, because there are so many issues that I know Planning Commission has tried when they're working on it to say, let's talk about Petrichor or let's talk about Central. It's interesting to me, and I see that they're different, I see that point being made. Normally from CEQA, the county's challenged and we're being concerned from the opposite side. So the challenges you see under CEQA, it's called piecemealing or segmenting, but you take a big project and you chunk it up into little projects because your traffic isn't going to trigger, 10 trips for that Measure E LOS, or you're not going to trigger a need for a big improvement because you've taken a big project and broken it up. So from a CEQA standpoint, I see a good argument. They brought us a big project, and if we start breaking that up, now we piecemeal it, so now the traffic counts are going to go down, and there might be impacts that you might not otherwise have if you didn't look at it globally, and the idea of it is globally. It was a developer decision, and they are doing some swaps with densities between the two properties, and so there was an incentive for them. They have said at the hearings that that's also what allows them to do the development agreement and to have certain pieces of the development agreement because it is such a large project. But that has been a concern that's been brought to the Planning Commission several times about why. I mean, I think my main response is really because the developer brought it to us that way. And I probably at one point would have had concern if we start breaking up a project that was brought to us, because that's where the CEQA challenges are, is breaking it up. But I do think it does put a burden on Planning Commission and the supervisors that when we have 4 hearings just at Planning Commission, because it is a big project and there's unique impacts and unique considerations for each piece of it.
And I addressed that you were there at the first hearing. My concerns along those lines, but then as Bre described, and also I talked to Tiffany in my staff meeting with her, that, okay, if you bring them in together, then you can see how they work, between themselves, interactively and so forth. But then the other side of it, maybe the third side, right, is because it's such a large project, they're doing a large lot final map, and then they're going to come in later once they get their entitlements and then do the individual subdivisions. So I've got some concerns along those lines because you're going to have further impacts that are going to be identified and mitigated down the road when the individual maps come in. So they're kind of taking a high-level look at this point, and those are some of the concerns that I've expressed about possibly splitting them up. So there's can be disadvantages and advantages depending on how you do it.
And Tiffany here is our county director of planning and building, because obviously planning is a major part of this. The building not so much yet, but the planning definitely is, so that's why you mentioned conveying or communicating with Tiffany as well as with Bre and other people. Because that's his role, is to try to gather all the information he can as best as he can understand it and ask the questions that the public would ask on their behalf to try to really do some fact finding to determine what are the hard constraints, what are the formal proposals, what are the options that might be available, is there conformance? That's the role of the Planning Commission. When it gets to the Board of Supervisors, that review should have already been finalized. There should be a recommendation to the board to break some of those things down. Sometimes there's additional conditions that are imposed that the board needs to consider. Are those reasonable adds to what the project was to make it the best project it can be, given all the other constraints? And the answer is generally yes. But it's a formal process, and everybody has their role. That's what I'm trying to figure out. The board's role, as Bre said, is to not spend hours and hours and hours going back through the stuff the Planning Commission went through. And we don't have the time for that. It's to use their knowledge, their guidance, their recommendations, parse it, spend the time on the things we think are the most sensitive, critical parts of it, and then make a decision. But you should go through all of that before you make a decision.
And a perfect example is the Vineyards project, where back in November, we heard that and we approved it, but we had no public comments. We had no one show up.
Well, CSD showed
This,
up.
well, okay, to be specific, well, the CSD provided, when I say public, I meant you public that live out there and so forth. We did have John and his group at APAC provided two separate submittals, and then the CSD as well. But we had none of the neighbors provide any comments in writing, nor provided any testimony at the planning commission, but then they came out like gangbusters at the board meeting. And so we really, truly want your input at the planning commission. And because we truly want to be able to vet these things out, and we do, you know. And so, and I'll talk a little bit more about that when I talk about vineyards. So that's a perfect example.
So, any final questions for Bre? Because I do want to.
The last one. Does CEQA consider the recreational value of the land in the county relative to the issue of environment?
CEQA has a section on recreation, but it is not the impact of the project to recreation. So I'm going to use a good example was the mosquito bridge, and the complaint was that we were affecting their ability to raft down the bridge. And I strongly took the position that that's not what CEQA was looking at. CEQA was not looking at our project as putting any bridge impact on that. It does look at, in that recreation section, the project's impact on recreational facilities. So if you're going to run down a park that's existing, or you're going to, make the pool here so crowded that you can't use it. So it looks at that, the project's impact on recreation facilities and the availability of that. Our general plan has different, obviously, pieces of open space in there. Does that answer that? So it's a flip.
It's not the
It may be
requirements
the
of
right
right
answer. I just wonder whether the recreational values of the county is an asset that has to be considered.
On CEQA. So CEQA, so the open space. So keeping that land as ability to have a golf course there, or something else.
Recreation.
Open space. I don't think so. I mean, I'm trying to think of how to phrase it as an impact on the environment. So if that open space was habitat for an endangered species, now, CEQA's extremely interested in that, or it has wetlands in it, or there's some environmental impact. Aesthetics, open space, offers you aesthetics, and so, if it was going to wipe out a view line on it, and there's public trails that go through there, CEQA does look at that. There's a case where, I forget there was some type of water structure, but there was some public trails, and we took away the views, I believe, of the beach. So CEQA does look at that piece of it, public views, so there's ways to get there. I don't know if just the open space in itself without kind of linking it to some environmental impact, but I can continue to think about it.
So I think Gavin had his hand up to take one.
I did. For the two parts, one zone for housing, one zone for open area, when does the rezoning process come into play?
So that's at the board approval. So if you look at the agenda item I gave you, that's one of the items there is to rezone. So that's when the rezone would happen at that approval. It doesn't mean the houses come right away. Those approvals keep coming, but the rezone would happen with this project right now.
And there will be public input for rezone.
Yes, and that's where the encouragement is to come next Monday, come to the planning commission process and make that public contributions and influence now while really the planning commission is.
But the board of supervisors will also conduct a public hearing where you take public testimony on things. So there's that next series of hearings, or a single hearing, depends on what it is. The size of the project is somewhat dependent upon whether it has to be continued or it can be resolved. But there's not only the opportunity of the planning commission, but there will be an opportunity for public input at the board hearings.
Thank you.
When is that board of supervisors hearing? Is that been scheduled?
It hasn't been scheduled because of the indefinite time frame at which the planning commission will finish their work up. And then it's going to take a little while for our planning department. So speculative is probably not into March. It's probably March would be my earliest guess.
There was at the end of the day today, they were doing a placeholder. I mean,
Okay.
placeholders are very uncertain, but March 10th was the,
Okay.
and the earliest one of when it would be done at planning commission and bring it up, but that can change, and it would be agendized and noticed, and, so don't write that date down and show up expecting it, that could change, but that was an internal staff work discussion.
Okay, last call, anything that's a pressing question for Bre? One last one, then we're gonna cut it off, so go ahead.
I have a question mainly for the planning commission, because.
Okay, he's here.
Yeah, right. I feel that all these projects that are building homes are going to have inhabitants that have children in the home. So I'm wondering if you don't have in that big thick book some sort of law that says, okay, builder, if you build 20 new homes, you have to put X number of dollars into the local school or more school buildings.
So Mitigation Fee Act and the mitigation requirements does require anybody taking out a building permit to pay fees to the county for our mitigations, to special districts. They pay it to the county, but it goes to the fire department, to CSE, for instance, in El Dorado Hills, and also for schools. So those mitigation impacts are defined, and when they progress a project to approval, there's some conditions set as to when those fees have to be paid, and that's collected through our planning department. So yes, is the answer.
And you, even if you do a home improvement where you add more than 500 square feet, you'll be paying school fees. So even for a home improvement, so, as well.
And the county does not run the schools, so they're separate under state law. The school districts are separate than the county, so we don't. But I mean, I know I pay millrates for the schools in my house where I live, so it does look good.
Thank you, Bre. That was excellent. I think that really helps.